Hi everyone, I am Masaki Ono, a senior patent attorney belonging to the Trademark division of Kan Patent Office in Japan. Today, I would like to present the fifth of mini lectures on the Japanese trademark practice. Specifically, I will very briefly answer three additional frequently asked questions about Japanese trademark applications. Now let's go. Question number 4. Is an intent to use required? The answer is yes. But you need not submit a declaration of intention of use or indicate such intention in an application form. Please note, however, that if you designate too wide a range of goods services in one class, you will receive an office action on the grounds of a reasonable doubt as to your actual or intended use of the applied for mark. Question number 5. Can I make a color claim? The answer is no. Instead, you can just put a colored mark drawing on an application form, based on which distinctiveness of the mark and dissimilarity between the mark and prior marks will be examined. Question number 6. Is a letter of consent acceptable? The answer is yes. The letter of consent system has finally been introduced in Japan and has been available since April 2024. One unique point is that it must be proved that there is and will be no likelihood of confusion between the goods services of the applicant and those of the owner of the cited mark in the Japanese market. Thank you so much for your kind attention. Please contact me anytime if you have any questions or requests about the themes of future lectures, or I can be of assistance. As I asked in the previous lectures, please call me Masaki, Nicholas, or Freddy as you like. See you next time.